So this is an ongoing topic about how lawyers set prices in criminal defense cases. You may have questions where you say, well, my case wrapped up very quickly. Do I get any money back? Or you may have friends who had a criminal case where they got money back from their attorney. So the question is, how do you get money back from your attorney, or when do you get money back from your attorney in your case? In Colorado, you should know exactly at what point your attorney is taking money from the trust account where you put money in to cover the cost of your case. There should be a retainer agreement that you signed, and it should list out very specifically at what stage in the case the attorney is allowed to withdraw that money. Now, for those of you who aren't aware, what happens in Colorado when you are working with a flat fee case, which is what most criminal defense attorneys do, is we as the criminal defense attorney have to take your money that you pay us and put it in a trust account. And then we bill from that trust account. So when the money is in the trust account, it is your money still. It still belongs to you. We're just billing against it. In our retainer agreements, the Colorado Supreme Court has said that we have to say in our retainer agreements at what point we get to take money out. Now, if your attorney is not giving you a retainer agreement, or you don't have a copy of your retainer agreement, that is a huge red flag, because number one, you need to be aware of exactly what you're paying for and when, and number two, that is a violation of their ethical obligations to you as the client. So you must have that retainer agreement, and you must have a copy of it for yourself so you know. Secondly, you need to be able to make a very clear decision as to when your money is being used. If you call your attorney and say, hey, what stage is my case in and how much money have you taken, and they can't tell you, that's another huge red flag. You need to be able to work with your attorney to know exactly when in the case you're allowed to have money withdrawn, or they're allowed to withdraw the money, and if there's any case or any stage in the case where you actually get money back. Now, as always, I can only tell you how we operate at Wright Law Group because I don't work in other firms, but at Wright Law Group what we do is we do it in stages. So depending on the stage of the case, we're allowed to take a certain percentage of the retainer agreement. We are very clear with our clients that if we don't do a certain stage of the case and that stage doesn't go, we get that money back to the client, because any money sitting in the trust account still belongs to you, the client. The only time the money doesn't belong to you as the client is once the attorney is able to pull the money from trust account, in other words, bill against the retainer and earn the money. When you pay an attorney, let's say you have a DUI case and you pay, let's say, $5,000 for a DUI. You pay that $5,000, it's supposed to be put directly into a trust account. Let's say the next day you say, nope, I don't like this attorney, I'm going with someone else. You better be getting a significant portion of that money back, because they do not earn the money in full when you pay them. It has to be put in a trust account. It has to be in that trust account for your protection, and you need to know exactly at what point they're allowed to pull that money out. The last red flag that I'll say is if you get a retainer agreement that says, hey, you pay me this money and I earn it all as soon as you pay it, that is not ethically allowed in Colorado. So let another attorney know immediately if you have a retainer agreement that says that, because that is not allowed in the state of Colorado. They cannot just take all of your money up front and not do any work to earn it.